Well, welcome everyone to our webinar on board and governance responsibilities for NDIS businesses. My name is Stephanie and my co-host is Joel, and we're really excited to be joining you today and talking about this topic. So looking forward to getting into it with you. But before we begin, just a couple of quick housekeeping notes to be aware of. So you'll receive the recording and slides of this presentation in your email following the webinar. So keep an eye out for that. Don't feel like you have to scribble down a whole bunch of different notes. You'll receive it all afterwards. Feel free to submit your questions in the Q&A box and we'll answer them at the end of the presentation. We'll have some time for that, but feel free to submit throughout the presentation if they come up. And also, please make sure to complete the feedback survey after the webinar. It's really useful for us to know about what was helpful, what you'd like to see more of in the future, so that we can keep helping you all out. Also, just something to be aware of is the fact that for the next 48 hours, you're eligible for a free consultation with LegalVision to discuss how we can help your business. So please just provide your contact details in that survey at the end of the webinar, and we can get in touch to discuss your specific questions. So just as an overview, today we're going to be discussing, just making some introductory comments to start off. There'll be some regulatory considerations that we run through. We'll talk a little bit about the impact of board and governance on your compliance. We're going to run through the director's duties and responsibilities that are specific for NDIS businesses, as well as just generally. We're also going to be talking about the consequences of non-compliance. So what happens if we're not compliant with the things that we run through? We'll talk a little bit about the penalties that might come with that. There'll be some concluding statements, and then we'll have time for those questions, as I say. So without further ado, let's just kick off and start talking about it. As most of you would be aware, the National Disability Insurance Scheme, or the NDIS, aims to provide more than $22 billion in funding to an estimated 500,000 Australians who suffer from a disability. Now, NDIS providers play a particularly crucial role, of course, in delivering those funded supports. Now, since NDIS providers provide support to a vulnerable group of people, your businesses and its activities are carefully regulated to ensure that participants are not taken advantage of. So this includes the very fabric of your business itself, its structure, its board, and its governance. The NDIS doesn't necessarily prescribe any one structure, and providers can range from sole traders to large corporates, charities, and not-for-profits. However, there are some essential choices that you can make to comply with your regulatory obligations, protect participants, and therefore protect your business. So Joel's going to run us through what some of those regulatory considerations are.
Thank you, Steph. All right, so if you want to run an NDIS business and you're wondering how to get started, the first step is to decide if you're going to set up an NDIS business or if you're going to purchase an existing NDIS business. Both of those are quite different, but we'll go through each of them in their separate slides. So firstly, setting up an NDIS business. If you want to set up an NDIS business, here are the steps to follow. Really, we're looking at step one, the most important step, in fact, which is to select what business structure you'd like to use. Now, there are several structures out there, as Stephanie mentioned. There are companies, trusts, partnership, sole trader, etc., etc. It is very important, though, that you decide on which structure is suitable for your business and that you set it up properly before progressing to the next steps. Step two, then, is to register your structure for an ABN. So once you have set up your structure, you need to register that structure for its own ABN. Now, remember, if you change your structure in the future, the ABN doesn't move, it doesn't change. You actually need to apply for a new ABN. This becomes particularly relevant in step three, which is registering for an NDIS registration. So once you have your ABN, you can then register for an NDIS. Note that your NDIS registration, it attaches itself to your ABN. And that's why I said in step one and step two, it's very important that you first set up your structure correctly and then you register for your ABN. because those two are the foundations for your NDIS registration. After you've done step 1, 2, 3, then you can proceed with the remaining steps. Step 4 is basically for you to self-assess yourself against the relevant NDIS practice standards. What these practice standards are, Stephanie will go through in a later slide. And then step 5 comes the verification audit and certification audit. You basically need a certified auditor to do this for you. And then step 6 is to set up your business plan. Now, while this is a normal step for all businesses, I want to specifically call it out here because there is this document called the NDIS pricing guide, which you need to be aware of because this determines how much you are allowed to charge for your NDIS services. But again, Stephanie will go through this in a bit more detail later. And once you've done steps 1 to 6, you finally get the exciting step, which is to launch. So that in a nutshell is how you set up your business. If you do not wish to set up an NDIS business from scratch, you can choose to purchase an existing NDIS business. Now, when we talk about purchasing a business, there's really 2 ways that this can happen. The first is to purchase the business. This is also commonly referred to as an asset sale, where you're using your own company or any other business structure as the buyer in that sale. The second option is to buy the shares in the NDIS company, an existing NDIS company, and take over as the owner of that company. So I've set out in a table the differences between the two in different segments of a sale. So if we look at the first row, which is registration, in a business sale, you need to be an NDIS registered provider already because you'll be buying just the assets of an NDIS business. It's your responsibility to get registered. The scope of the registration will need to be registered for the business that you are purchasing and that you intend to keep providing. You obviously need to ensure that you have suitable key personnel to deliver NDIS services, and you need to ensure that from the date you purchase the business, you can comply with all relevant NDIS laws. And finally, with customer contracts, you need to arrange with the seller for which contracts go across to you. They may be obviously NDIS disclosure and privacy related obligations by doing so. But that's business purchase. In the rightmost column are really what you need to look out for if you are purchasing the shares in an existing company. So that's really what you're doing. There's an existing NDIS registered provider, and you are buying the shares and taking over as owner of that company. So you just need to make sure that after the sale, you update the NDIS commission through the portal. You also need to make sure that the company has been registered for the services it's providing, because you don't want to inherit a default company. The key personnel, you have to make sure that the company has always had suitable key personnel, and you have to make sure that it will continue to have that key personnel. And finally, compliance with laws and customer contracts. Compliance with laws, you need to make sure that the company has been complying with laws because you are inheriting the company for better and for worse. So you just want to do that in due diligence. And obviously post-sale, you need to make sure that you continuously comply with NDIS laws. For the customer contracts, because you are buying the company, you will be inheriting all the contracts to which the company is a party. So there's not necessarily any transferring or novation of contracts. You're really looking at taking over the contracts. However, there may be change of control clauses you need to look at, and you may still need to update your NDIS participants with regards to the sale. So in all of this, you will notice that NDIS registration was a common theme in a lot of what we just covered. So now that we know how to set up or potentially purchase an NDIS business, I'll let Stephanie walk us through how board and governance will generally affect NDIS registration.
Yeah, no worries. Thanks, Joel. Just as a general note before we kick off this kind of discussion is just to say that we want to note that registration is not currently mandated to be an NDIS service provider unless you're providing certain types of services, such as specialist disability accommodation. But there are some recommendations which will likely be implemented in the near future that will change the registration process. And some level of registration is likely going to be compulsory down the track. Now, what's been suggested at this stage is a tiered approach. So depending on the types of services that you provide, there may be different tiers or types of registration to engage with. Since this is a developing area, we're keeping an eye on the space, and there'll be updates hopefully in future webinars that we can discuss, but also recommend that you keep an eye on those changes as well, just to make sure that you can be continually compliant. With that said, registration with the NDIS is highly recommended to establish your reputation as a business and ensure that you're compliant at every stage. So, if you do intend to register with the NDIS, you will be expected to comply with the relevant NDIS practice standards and quality indicators based on your registration group, which is what Joel mentioned earlier. The practice standards set out that NDIS registered providers are expected to achieve the following kind of outcomes for participants. That major outcome is that each participant's support is overseen by robust governance and operational management systems relevant or proportionate to the size and scale of that provider and to the scope and complexity of the supports that are delivered. So that's the overarching goal. Let's have a little bit of a better look at what, in simpler terms, that might mean. So the practice standards suggest, in very simple terms, that you must let participants have say in decisions and rules that affect their service provision, have a clear structure to handle money, follow laws, and keep participants safe. Make sure that you and your team have the right skills and knowledge to be able to provide the services. And if there are any gaps, just make sure that you are able to provide the appropriate training as needed. You'll need to be able to plan for the future, considering changes in the law, as we've discussed, potential risks that could arise, the NDIS rules, and what participants and workers will need now and on an ongoing basis. You'll also need to make sure that you're checking in with your managers in particular, make sure that they know what they're doing, and see if there are any room for improvement areas for them. That's part of having qualified people in charge who have clear roles and responsibilities and clear lines of reporting in the event of any issues. You'll need to ensure that there's continuity of care so that each participant has access to timely and appropriate support without interruption. So if somebody is not able to attend a shift due to sudden leave or sickness, you need to be able to make sure that you have appropriate qualified people who can step in, that the participant is comfortable with, and that you can provide those services to quickly. As a general point as well, you'll need to ensure that you have emergency and disaster management plans in place and deal with any potential conflicts of interest openly and make sure that you have rules about how to handle them. So a conflict of interest may arise if you provide different types of services, say if you provide support coordination services as well as general support services. That's a conflict of interest, and you need to declare to the participant that you don't intend to only refer your own services to them as part of your support coordination services. So that's something to consider, and there are important policies to have in place about that sort of thing to ensure you can comply with the practice standards. So if your approach to board structure and governance does not achieve the aim that we set out at the start, you will be unlikely to receive registration. So if you already have NDIS registration, but you let slip on some of these standards, an issue may cause these matters to come to the surface. So it's likely to arise that this will be looked into if some sort of issue does come up. Alternatively, a routine audit may even find an issue with these sort of governance standards. We'll be in touch more about consequences later in the presentation, but it's important to remember that the practice standards and quality standards are central to your ability to comply. What's also central is what your role is as a director. And so I'm going to pass to Joel now to run through those responsibilities.
Thanks, Steph. So if your NDIS business is a company, you will have the same director duties as a director of any other company. So mainly I want to cover what I call the big four. And these are the big four director duties that apply to all directors. The first is the duty of care. The duty of care is really the duty to exercise a reasonable degree of care, skill, and diligence. Now, an example of this is the expectation for every director to be aware of the business operations, the business's financials, and to take the necessary decisions in light of those operations and financials. The duty of good faith is slightly different, but has a lot of overlap. It's basically the duty to act in good faith and in the best interest of the company. But because we're talking about NDIS, this also extends to your NDIS participants. Now, an example of this duty is where directors should not use their powers for an improper purpose. So an example includes issuing shares to yourselves in order to dilute the other shareholders. So things like that, generally not permitted. The third of the big four is the duty to avoid conflicts of interest. This is the duty to avoid and to declare conflicts which may arise, and to also not misuse your position and the information you receive as a director. Now, this duty is fairly explanatory, I suppose, but remember, the directors and shareholders are separate from the company itself. So you cannot enter into transactions or deals in a way that favors yourself or your other businesses or your other companies, and to the detriment of the one company. Now, this is actually quite prominent in the industry, as Stephanie flagged earlier, because there are quite a number of NDIS providers who actually do more than one type of NDIS services. So one, for example, might be doing plan management, and then you have another company that does support services. So you need to really be careful of this duty, particularly in the NDIS space. And the last of the big four, but by no means the least, is the duty to prevent insolvent trading. Fundamentally, it's the duty to prevent your company from going insolvent. Now, I'd like to dive a bit more into this particular duty, as this is particularly important, I think, for NDIS businesses, especially because they need to operate within the parameters of the NDIS pricing guide. So, what do you do if you suspect your company may be insolvent? Right. Fundamentally, as a director, you really need to be familiar with your businesses. There's no excuse to this. Now, the warning signs of insolvency include ongoing losses, poor cash flow. If your business plan doesn't exist, if you have incomplete financial records or disorganized accounts, if you're lacking in cash flow, increasing debt, problem selling, stock, overdue taxes, it's the general red flags from the financials, right? Those are the signs of insolvency, and it's your duty as a director to always be on top of it. It's not enough to just palm it off to an accountant and say, oh, I hired an accountant, they will tell me. As a director, it is your obligation. Now, there is a defense that was introduced not too many years ago called the safe harbor defense. Now, this defense is available to directors in order to allow them to start developing one or more courses of action that are reasonably likely to lead to a better outcome for the company, rather than just, putting your hands in the air and saying, let's just appoint an administrator or liquidator. The idea of this defense was to try to promote ongoing business operations, to try to salvage your own companies. But the key to making yourself available to this defense is to ensure that you document what you're doing and why you are doing it. And that's the fundamental part of this defense. However, the grand rule, the golden rule is, if in doubt, get insolvency advice and get it early, because in insolvency, time is of the essence. Every minute counts. So I'll now pass the baton back to Stephanie, who's now going to walk you through some NDIS specific duties.
Thanks, Joel. Yeah, for NDIS specific businesses, as a director, your duties are same, but different. So you have these existing director's duties and then some additional considerations. As under the NDIS, your role is known as what's what's called a key personnel. So you're the key personnel of your business. In order to become key personnel for your NDIS business, there's a suitability assessment that's attached to that, and you must hold an NDIS screening check. The suitability assessment will investigate whether you've been subject to a banning order, convicted of an indictable offence, whether you've been subject to an adverse finding or enforcement, specifically with regard to providing services to people with disabilities, to older people or children, and it will also investigate under ASIC and other such organisations. The suitability assessment will also look into whether you've been subject to any judgment in relation to fraud, misrepresentation, or dishonesty, or if you've been disqualified from managing corporations. So once you have the suitability assessment and you're allowed to be key personnel for your business, there are some simple administrative obligations that come as part of that, such as keeping the NDIS Commission informed about your information and contact details and making sure that that's up to date at all times. You also have to make sure that you keep the NDIS Commission informed of any changes in the key personnel of the business, if there are any significant organisational or governance changes, or if any event occurs that's likely to affect the suitability of the key personnel. Now, though these are not strict legal standards, what I'm about to share, there are some general obligations that you can consider as well on top of these existing obligations that can help you to be compliant. So consider how you can keep on top of regulatory changes, including annual changes to the NDIS price guide. As Joel has said, this will significantly affect your service pricing and also affects things like cancellations, how much notice both you and a participant needs to provide in terms of cancellations of a shift or your arrangement with them totally. It also will depend on the type of services you provide. So if you have programs of support, there are specific sections in the NDIS price guide that you'll need to adhere to. So staying on top of those annual changes will be essential, and there are many different ways that you can stay informed. LegalVision puts out particular pieces of information that you can keep abreast of. There are also many other very significant organisations that share information like that. So consider how you can get looped into those communications. You'll also want to make sure that you identify and manage risks to your business and participants. So keep an eye on if there are particular things happening across the business that seem to be concerning. That's important as part of overseeing the quality of the care and promoting a culture of integrity and ethical work, including strict adherence to the NDIS Code of Conduct. As part of that, you want to make sure that you're driving continuous improvement in the business. NDIS is a very novel space, as many of you would be aware. Things seem to change all the time. So as part of growth, continuous improvement is important, and partnering that with NDIS means staying on top of a very novel area. I'm just going to pass back to Joel now to discuss what some of the consequences of non-compliance might be.
Thanks, Steph. So the consequences of non-compliance with your board and your governance duties come from two locations broadly. The first is the Corporations Act, provided your NDIS business is a company, and the second is the NDIS laws. I'll go through the former. So there are personal legal liability for directors of an NDIS company. Now, these can include declarations of breaches, which is usually a court statement saying so-and-so has done something wrong. It could include compensation for the company payable by the director who's breached their duty. At this more serious end of the spectrum, you could also have disqualification from being a director of any company for a number of years, and potentially at even further extreme end of the spectrum, you can have civil and criminal penalties attributed to you. That includes $1 million in fines or up to 3 times the benefit you have received, or 15 years imprisonment. Now, these are, of course, the worst case scenarios, but there are also other intangible risks that you should be aware of, and you probably already are aware of, such as reputational damage, decline in market visibility, trust, and difficulty to grow the business moving forward. Now, amongst NDIS participants and providers, there are many stakeholder groups, and word tends to travel very quickly about the providers who have been non-compliant. In addition, media coverage is common, as I'm sure you would have all already noticed on the papers and on the news. Missteps can also mean that NDIS Commission may increase their auditing on your business and enforce stricter monitoring moving forward, which obviously leaves you with a bit less room for error. Now, all of these, while intangible, obviously can have indirect increased cost for compliance. Now, there are also NDIS specific penalties, and I'll pass back to Stephanie to go through them.
Thanks, Joel. Yeah, so the NDIS Commission is the primary player in this section. So the NDIS Commission itself can apply various fines and penalties for governance failures, but the exact amounts can vary based on the severity and the nature of the breach itself. So there are civil penalties that could be applied for serious breaches. They can range up to $210,000 for an individual and over $1 million for a body corporate per contravention. So that's worth noting. If there are multiple contraventions as part of the issue, multiple fines could be applied. The NDIS Commission can also issue infringement notices, similar to what Joel has already discussed, but less severe breaches might result in these sorts of notice, typically also attached with a monetary penalty between $2,000 and $12,600 for individuals, and from $10,500 to around $63,000 for body corporates. There are also compliance notices that could be issued. So while this is not a fine expressly, these do require prompt action to address issues that are stated in the compliance notice, with potential penalties then applied if there is non-compliance for the remedies. The NDIS Commission can also issue enforceable undertakings, which are legally binding agreements to take specific actions to remedy an issue, again with court enforceable penalties for breaches of that undertaking. There's also the potential for registration with the NDIS to be suspended or revoked entirely. So I'll just pass back to Joel now for some concluding comments, and then we'll take your questions.
Thank you, Steph. So as a director, as a leader of an NDIS business, it is essential to fully grasp the gravity of your governance responsibilities. The regulatory landscape of NDIS is very stringent, and the focus is really on quality and compliance. And that means that the board really is your governance responsibilities. It's not just a formality, it's a critical aspect of the business. The board's governance will directly influence your ability to successfully register and maintain your status as an NDIS provider. Understanding your duties, whether it's under corporate law or whether it's under the NDIS specific laws, is crucial to avoid, obviously, all the severe penalties we've gone through and generally for the continued success of your business. Non-compliance is not just a risk for the business, of course. It can have significant repercussions to you personally as a director, as a key personnel. We've gone through those before, and the consequences can be quite far-reaching. Now, in closing, moral of the story is to prioritize very strong governance. Stay informed on all the regulatory changes and ensure that your business is always operating within the legal framework. This is not only going to protect your business and your personal standing, but it's just to ensure the highest standards of service delivery to, what is a very vulnerable group of people. So that really concludes the main part of our webinar. You might find our publication on Board Reporting Toolkit useful. You can download it in the Resources tab or just by scanning the QR code you see on the screen. You might also be interested in one of our upcoming events, Workplace Policies, what every employer needs to know. It's scheduled for Thursday, 19th of September at 11 a.m. Sydney time. There's a link on the screen through which you can register for that event. Now, we are going to answer your questions very shortly. We'll give you some time to submit them, but we'll take a minute just to tell you about LegalVision's membership. By becoming a LegalVision member, your business gets unlimited access to our team of over 100 specialist lawyers, including NDIS lawyers. And This covers all your business as usual legal needs. It's pretty much like having your own in-house counsel for a fraction of the cost. Our team can assist you with unlimited document drafting and reviewing of business contracts, unlimited legal advice consultations, unlimited domestic trademark registrations, and so much more. Now, as a LegalVision member, you don't need to worry about the cost of lawyers. We'll take care of all your business as usual legal needs, and you can just focus on running your business. And to learn more about how our membership can help you, just feel free to request a free consultation when the survey ends at the end of the webinar. So we'll now answer some of your questions. There's a question come in about owning two NDIS companies. Steph, do you want to maybe have a go at this?
Yeah,
First?
absolutely. So we've mentioned it a little bit throughout the presentation, just about conflicts of interest. That's probably a key point. So you'll need to be aware of the fact that you'll need to disclose to participants, specifically on that conflicts of interest point. So if you're providing different types of services under those different businesses, you'll want to make clear to a participant through a conflict of interest policy that basically you're not going to be only benefiting yourself, and that here is the conflict. Participant can be aware of that, acknowledge that, and also ensure that there's proper acceptance of that. That's a really key aspect of owning those two companies and how to manage that appropriately. The other thing to be aware of course, is those different directors' duties. So you'll need to make sure that you can fully act in the best interests of company A and fully act in the best interests of company B without those two types of interests conflicting with each other. So those directors' duties remain paramount for two different kinds of businesses. As long as you can hold both in tension, that's the really key part of compliance. Joel, did you have anything you wanted to add to that?
Yes, definitely. And you would remember potentially from one of our previous slides about the big four directors' duties, one of which was the duty to avoid conflicts of interest. This is where this plays out, right? You need to properly disclose this, give full and frank disclosure to your shareholders and your directors. If you're the only one who is in this position of conflict, you may also need to abstain from voting on whether or not to transact in this position of conflict. And fundamentally, you need to be aware of your governance responsibilities, what's written in the Constitution, what's written in your shareholders agreement, and you need to follow due and proper process. Further to that, we always say and always recommend that even if you have related companies providing services to your NDIS participants, try your best to transact at arm's length, because that's one less problem you need to be worried about if ASIC ever comes looking at your group structure.
Yeah.
So yes, there's a question that just come in as well, which is, are there any specific requirements for NDIS businesses in relation to offering shares in the company via an employee share plan? Not really. The responsibilities, your responsibilities as a director or a member of the board is the same as any other company. You need to obviously potentially set up your employee share plan in accordance with your constitution and shareholders agreement, and then have them issued. Yeah, the fact that you are in the NDIS space doesn't really change anything. Yeah.
There's a question that's come in as well, Joel, just about home care businesses and what the pros and cons might be of being a franchisee for those home care businesses. So I might just run through some quick high-level pros and cons for that approach. With becoming a franchisee, generally, regardless of whether you're an NDIS business or not, the pros of becoming a franchisee is usually that there are established brands and systems. Now, the consideration for an NDIS business here is that it's more likely that that's compliance, since they have the pressure of helping other businesses comply, and to establish a network of businesses, it's likely that there would already be registration and compliance systems in place for you to be able to follow. That's not always the case, and we can't guarantee that. But it could play into your decision-making about whether you choose to become a franchisee or not. As well as that, normally the franchisor will be providing training, support, the appropriate documentation that you need to use. It's potential for easier market entry. which means that, yeah, you can basically have access to clients and participants much easier than when you're starting from the ground up. And there are also shared other resources for marketing, and you have a proven business model to work with to be able to establish the business itself. The matter of registration becomes a little bit more complicated in terms of how the franchise is set up and whether you can access or have some sort of license arrangement basically to the NDIS registration. But what we would generally recommend and consider is making sure that you yourself are compliant and can become registered if necessary. So that's some pros to consider. Some cons are the fact that there are obviously franchise fees and ongoing royalties and payments that need to be made to the franchisor. So that can be a drain on your personal business resources. There's less autonomy in business decisions. You don't get as much say in how things go. There are potential territory restrictions. You may be restricted to only working in one area or with a certain type of client or with a certain type of service. There's also a dependence on the franchisor's reputation. So if they misstep or something goes wrong, your business is attached to that, and their non-compliance very quickly becomes your non-compliance. As well as that, there might be specific limitations or obligations depending on who the franchisor is. So it's quite a complex area and quite context specific. So I really recommend that you have a look into getting franchising advice specifically on this. It's definitely done in lots of different ways and by lots of different businesses to great success, and for some with some difficulty. So I would highly recommend getting specific advice on your needs.
Lovely. I can see as well there's a question come in about the reporting side of things, how it works, what's mandatory, what isn't. All right, so it's going to be very context specific. Obviously, depends on what kind of NDIS services you are providing. That will obviously determine what your reporting obligations are. But at a very high level, most NDIS providers will need to do incident reporting, service delivery reporting, progress reporting. You obviously need to keep good records and plan reassessment reporting. Now, incident reporting is basically one of the most important areas. You just need to make sure you are on top of incidents such as death, injury, abuse of participants, and that these are reported to the NDIS Commission within 24 hours. And you generally have 5 business days to report on the use of a restrictive practice on a participant if that's not in line with your behavior support plan. Service delivery reports, on the other hand, it works where the NDIS providers generally are expected to keep full and accurate records of the services that you provide. This includes type of support you're giving, frequency, duration. Now, this documentation is the responsibility of the provider itself, but you can, of course, use dedicated software to help you deliver such reports. Progress reporting is a crucial area especially in the realm of support plans. These should include reports on the function, participation in activities, achievements against NDIS goals, any challenges the participants are facing, things like that. It's important, obviously, to capture the impact of the supports that are being received by the participant to make it easier to monitor their progress. In terms of record management, this is all businesses, but particularly NDIS businesses. You really need to maintain accurate and up-to-date records on all the activities relating to service delivery, billing, incidents, progress, and goals. A lot of it overlaps with the first 3 that I mentioned earlier, but yeah, just be on top of your records. And finally, plan reassessment reports. This is to help NDIS understand what participants need as part of the reassessment process to help them better realign to their goals. So for these types of reports, generally NDIS is expecting detailed evidence-based recommendations to help them decide on their reassessment of supports and services for the relevant participants. So yeah, that's in a nutshell, the high-level reporting requirements of NDIS. And yes, as a director, as a leader, as a key personnel of your business, this falls on you. It's to make sure that this gets done.
Absolutely. Something I'll add to that, Joel, is just to say that where you're entering into arrangements with contractors or perhaps another even a labour hire business, let's say, who might be supplying people who provide the actual supports to an end participant, this will be a really, really crucial area to keep on top of. That turnaround time for incident reporting is quite short. So making sure that you have appropriate contractual obligations on a particular contractor or the business that's responsible for that contractor to make sure that information is getting fed back to you so that you can comply with your obligations. That will be a really, really key area to have an eye on and make sure is included in any contracts that you either have drafted for you or review. Just because it's not always practicable to provide every single service yourself, part of business to partner with people and make sure that they help you out. So as part of that, reporting is going to be a really crucial area. So just another general question that's come in that I might have a look at now is just about what are the kind of significant risks that are facing NDIS businesses? Obviously, this is a quite broad question, so I'll give it a relatively broad answer and hopefully capture some of your concerns. But if you have something specific, please feel free to book in for that consultation, and we'd love to have a chat about what your concerns are. The main thing to be aware of, as we've spoken about across the presentation, is changes. So you'll need to be aware continually of the NDIS pricing guide, the changes to that pricing guide, and changes in the types of services that you can offer. NDIS is still relatively new, only just over 10 years old. So things are constantly getting added and changed. The levers are being pulled to see what we can do, basically. So keep an eye on what changes. Make sure that you can have the pricing guide as a primary consideration, because cash flow will be really essential to make sure that your business keeps running and is profitable and growing. And cash flow, as Joel has spoken about, will be important for watching out for those insolvency risks. The other part of that, as we've said, is knowing about complying with the NDIS laws. So legal support in this area is really important. Apart from the penalties we've mentioned, as we've said, the non-compliance can have direct financial implications on your business. So if claims are submitted incorrectly for payment, the NDIA may delay or reduce payments until those errors are rectified, which can have a significant impact on you and on a participant. And then failure to adhere to terms and conditions of a funding agreement can also result in reduced or withheld payments. And that ties back again to the duty to prevent insolvent trading, as I've mentioned. So if insolvency does happen and you want to avail yourself of the safe harbor defense, make sure again that you're documenting the what and why of your actions and reason and responses to things. So it's a highly regulated space. The kind of risks that can come up for NDIS businesses really vary widely. Each participant has unique needs, and therefore there are novel issues that could come up with specific participants. For that reason, having access to legal support that you can reach out to and chat through a problem, see how you can approach it in a way that is compliant, is really helpful to be able to make sure that you can stay on top of things as they change, as they develop. So hopefully that was helpful for you.
Thanks, Steph. Yeah, so that's all the time we have for today. Sorry if we haven't answered some of your questions, but remember, you can submit your details in the survey at the end for any assistance with questions that we didn't get to answer, or if you want to learn more about how our membership can help you. Now, while this was and is a free webinar, we value your feedback a lot. So we'd really appreciate it if you can complete the 30-second survey at the end. But otherwise, thank you so much for joining Stephanie and myself, and have a great day ahead.
Thanks all.